Whitfield, recording on Tuesday, July 17, 2018. First and 14th Court of Appeals of Texas. Hello. Yes, sir. I would like to speak with Mr. Chris Prime. Please move yourself over. Sir?
How can I help you?
Well, I'd like to speak with Mr. Chris Prime, and I would also like to file this document.
Okay, I don't believe he's available right now. What is it that you need to discuss with him? You can discuss it with me.
Okay, I need him to be aware that Judge Phillips has appointed Sham attorneys to block our claims that we have in our motion for new trial, and I need the court to please dispose of our issues because we need our issues addressed.
Okay, we'll submit the I assume you state all that in your document here.
But I did it like you informed me to do, so I did it this way: hers and my, one letter, and two.
Well, Mr. Whitfield, I told you that you can't combine more than one type of pleading into a single document.
It's a letter and a motion.
Okay, well, it technically should only be one or the other. It can't be both. Okay, but I'm going to go ahead and take it in. Okay?
Okay.
And I'll go ahead and file it for you. But again, now for about the fifth time. Okay? When you're filing something with the court, if you can't file one document as two different things. It needs to be, if you want to file a letter to the court, then you file a letter to the court. If you want to file a motion, then you file a motion. It can't be both.
Okay, let me just for clarity, because I'm not understanding, because I see attorneys, and we do it all the time in federal and state practice. They're documenting what we call the caption or body of the instrument itself. It could be counsel, or rather defendants or plaintiff's motion for summary judgment and attorney's fees.
Trial court documents, sir. This isn't the trial court. This is the appellate court.
What in this court?
If you file a motion, let's say you try to attempt to combine two motions, which you've done before, a motion asking for this and then that, so two different things.
Mm-hmm.
Okay? The court can't deny one document. Okay, they can't grant one part of it and deny another part. That's why they have to be two separate documents, so that the court has the ability. Let's say you're filing a motion to extend time to file your brief and a motion to file late notice of appeal, just as examples. Okay, the court could grant your motion to file your late notice of appeal, but deny your motion to extend time to file your brief. That's why they have to be two separate documents, so that the court can address each one of those issues individually in its own document.
And I get
That's
that.
what's required.
And I get that, but as you know, I'm sure you know, when you see a written order, plaintiffs, order usually, I hear what you're saying, but this is what I'm so accustomed to, an order stating, it'll say this, and the court will render the following orders. Whitfield's motion for this is denied.
Man,
Whitfield's motion.
You're trying to practice in the appellate court the way the trial courts operate, and that's not the way that it works here, sir. We're two different levels of
right. And appellate, federal,
we have our own set of rules. Okay.
Can you print me up? And I don't want, because this is probably because we're trying to get attorney. But can you tell me where I can go to get you all's local rules?
There are no local rules except regarding electronic filing. And all of that is contained in the Texas Rules of Appellate Procedure. You clearly have access to a computer.
Right.
You can just do a Google search, and they're contained in the appendices of the Texas Rules of Appellate Procedure at the end.
Okay, just to be clear, the 1st and the 14th Courts of Appeals have no local appellate
rules.
That's what I'm saying.
Electronic filing. And again, as I just stated, they're contained in the Texas Rules of Appellate Procedure.
The local rules.
At the end of the Texas Rules of Appellate Procedure.
Okay, at the end. And the appendix.
Correct. In the appendices of the Texas Rules
Let
of
me
Appellate
confirm.
Procedure. All 14 courts. Local rules.
And each court's rules are...
And each one of them are
different.
Are separate.
Yeah, are separate.
Local rules for the first, local rules for the second, local rules for all the way through all 14 courts.
And it will have the motion practice.
It has all
okay, all right. All right, then, yes, well, okay, then because I haven't seen it, and we supposed to be represented by attorneys now, and they're not, the Judge Phillips and the appoint them in, for Sham, we're not supposed to be doing this anymore. We're supposed to be at the FBI and doing a food and water strike. And so it's stressing me out. It's so much going on. So this hopefully will be the last time we'll have to come here in this case.
And I'll get it. I'll submit your document when you get it stamped.
Okay.
And understand, Mr. Whitfield, there's nothing that all we can do is submit them to the court.
I get it.
Above and beyond that we can do.
Right, because I see Justice Higley keeps signing orders. For example, she'll say there's no right to self-hybrid representation. We're not trying to represent ourselves with counsels. We're just trying to bring to the court's attention that these attorneys are not.
Is this your stamped copy?
Yes, sir. Well, let me make sure you have the original with the ink. So this got to be ours because one page, the last page is not here.
I think it's right here because it kind of moved over.
Well, yeah, then you have the original at the very last page.
Here, I'll let you.
Okay.
You know where it's at.
Okay, so that's the ink pen signature signed by her, signed by me.
And this is the one I'm keeping.
Yeah, that's the one. Okay.
All right, we'll get this submitted to them, Mr. Whitfield.
Okay.
And like I said, above and beyond that, there's really nothing that we can tell.
Okay, I get it. I just don't have to, break down and do one. It takes so much time to do this, and you try to, just to present separate motions and separate documents. But hopefully,
But understand that we're not treating you any different. Again, as a pro se litigant, you're required to adhere to the trap rules and the rules of appellate procedure, and the court's operating procedures, just as an attorney would. Okay.
Exactly, and it does say that.
And we would not allow an attorney to file a motion that requested two different types of relief, or to file a document that was two different things. We would reject that. They would submit it electronically. We would reject it and tell them they need to be filed as two separate documents.
Then I thank you, sir.
Okay. So we're not treating you any differently than we do anybody else.
Yeah, I see that because.
But understand that goes both ways. When it's good for you, when it benefits you, we're not treating you any different. But when it doesn't benefit you, we can't treat you any differently because you're representing yourself pro se. We can't give you any special treatment that we wouldn't give the attorneys or anybody else.
Right. Okay. So what I was gonna say to Mr. Chris Prine for her and myself is that she is represented by an attorney, but the attorney is not only not communicating with her, but ignoring.
Appointed or retained?
He's appointed.
Okay.
And he's not presenting the issue.
Can you file something in writing with the court, bringing that to the court's attention?
That's what we're trying to do with that.
That's what's in this document?
Yes.
Okay, if you've spelled that out in this document, then we'll get it before the court and they'll be made aware of that.
Okay, thank you.
Okay?
All right, thank you. All right, bye-bye. You too. Okay, you heard it will be presented to the court because that's what's going on here. We're getting attorneys presenting issues that do not. Come on, Brandon, if you could. No, we're going to the house. Okay, thank you. I thought y'all were over here. Okay, thank you, sir. All right. These attorneys are standing in the way. Let me make clear to the world, to the FBI, President Donald Trump, Attorney General Jeff Sessions, Director of the FBI, and United States Human Health and Safety, Office of Inspector General, U.S. Department of Justice, Office of the Inspector General. So I've named two different Inspector Generals in the federal government, one for the United States Health Department and the other one for the United States Justice Department. We are victims of healthcare fraud and retaliation. The allegations against us for child abuse are frivolous. They are, okay, I said frivolous. They are retaliation, and they are to prevent us from exposing healthcare fraud. That's what this is about. We have a judge, John F. Phillips, committing crimes. So I want to, and any attorney that were to go on CNN News or any other network would say that claims such as fraud upon the court, perjury, deprivation of right of trial by jury, self-representation, and violation of the Fourth Amendment, such as law enforcement and CPS entering our home without a court order and an emergency. Those are claims that are what they call cognizable. Those are claims that are capable of being tried by the courts. And you have to present these issues because there are doctrines that the federal courts have put in place, federal law, that you cannot just go into federal court with issues that you have not given the courts of the state an opportunity to address. Our attorneys that Judge Phillips appointed will not and have not presented we see the state Texas rules, Texas State Bar rules on professional conduct state that those are attorneys play different roles. Keep this video at 20 minutes. Attorneys play different roles. One, they provide advice, representation, and they also act as advocates. We already presented our motion for new trial, an amended motion for new trial. We just need assistance, such as the lawyers getting the videos from the hospital, Memorial Hermann Hospital. We need, let me guide you out. We need the video recordings to show healthcare fraud and kidnapping under Texas law. Texas law has earth, wind, and fire are like elements. Like the universe is comprises of elements. Kidnapping comprises of elements. These people were acting on the color of state law, refusing to claim and pretending that back up Brandy, purporting to have a right to hold her, but they lied, saying that she told them she was hearing voices that told her to kill herself, even though I'm trying to record her saying they lying on me. I never told her. That's enough. I never told them anything like that. And won't let me. Now, the hospital was private, but it was open to the public. So when they open, even though it's private, if you are open to the public, then I can record. Now, there are HIPAA violations. Slow it down, go out of easily. There are HIPAA violations. There are some parts of the hospital that I cannot record, such as but my wife, that's like in the emergency room where only she, myself, and these employees of the hospital are only being video recorded. And, there's no HIPAA violation. 8 more minutes to record. So I was allowed to record. They were, even though it was private, so long as other people, see that like in certain areas of the hospital, I can't record because that would violate HIPAA, but in the emergency room or wherever, the rapid treatment area, there was no HIPAA violation. Where you see me recording, that would not have been a HIPAA violation. This is where the public has access. It's not where someone is in a private setting in a hospital, like an operating room, or where they're discussing psychiatric issues and things of that nature. That would be a HIPAA violation. Your turn right here. Okay, I'm recording. So we don't want to be saying, just go all the way down. My wife was wanting me to make sure I give her correct directions. So, but I want to stay on point in 20 minutes. I've been told to have a topic sentence, a subject matter by a photographer and news journalists to keep it in one paragraph when we do go to the FBI. And there's a reason that we were supposed to have gone to the FBI yesterday, but I need, I do that in a separate video why we were not able to have gone yesterday. But the purpose of this video, as will be stated in the caption, is to prevent Justice Higley of the First Court of Appeals in cause number, appeal number 01-18-00311 CV, or the panel or an en-banc court from saying that there's no right to hybrid representation. We don't want to represent. We don't want to act as co-counsel. That's not why we want our attorneys. Our attorneys have to present our issues. They have to act as our advocate. Those are the professional rules of conduct by the State Bar of Texas. They cannot, as what they're doing is standing in the way and not presenting our issues. They were not at the trial level. They can't just go on what they see in the record when we're telling them that Judge Phillips prevented the issues that would expose his crimes and the Harris County Attorney's crime and the assistant prosecutor and the attorney forced upon her. That's why there's such a thing called a motion for new trial, which requires an evidentiary hearing to adduce facts which are not otherwise in the record. Now, we're not asking or demanding that these trial counsel that Judge Phillips has appointed to protect him to present frivolous issues. The issues that we have are what they call cognizable. So, world, cognizable are fraud upon the court. That's what we're alleging. So we need a evidentiary hearing to adduce the facts to support it and prove it. He cannot, the attorneys cannot deprive us of that claim by not raising it because Judge Phillips told him not to do that. You work for me. You're not going to raise that. That will get my ass, that will get me arrested. That will get me removed from office by the State Commission on Judicial Conduct. If he prevails, they prevail in their claim of fraud upon the court on me and the court reporter for doctoring the record. The court reporter's record does not reflect what our audio recorded. For example, Judge Phillips telling me to bring my attorney to court, and he said a lot of things. The court report has things that he recorded, but the audio that I recorded shows that's doctored, that's fabricated. So the court reporter is an officer of the court. Only an officer of the court can commit fraud upon the court. Judge Phillips is an officer of the court, and he committed fraud upon the court by claiming that he held an evidentiary hearing and rendered emergency orders when in fact he held no such hearing. On May 8th of 2017, the federal constitution required him to conduct what Texas law calls an initial hearing. He did not do that. And the proof will prove that he didn't because, as the FBI stated in early May of this year, we'll get the audio recording surveillance. My mother is a witness. She was there all day from the time the courthouse probably opened at 9 o'clock until they filed that petition to terminate our parent-child relationship rights. She was there before I got there. They took me to jail. The videos proved Paul Gonzalez is the person that they say presented his petition and the judge acted. Paul Gonzalez, they don't want to tell he quit. He quit because they didn't hold the initial hearing, and CPS won't tell us where he is today. Not that they have to, but they have to tell an attorney through discovery, so we could have gotten him in Paul Gonzalez's testimony, my mother's testimony, as the FBI put it. The surveillance recording will show that Judge Phillips never, and these issues they don't want to present that they don't want us to have where we can get the United States Department of Health and Safety, the United States Department of Justice, Inspector General, to show that FBI and the United States Attorney, for whatever reason, they won't let it. We're telling them demanding committed crimes, and we can prove it, but they don't want it. You took our fucking baby from us, man. Fuck wrong with y'all. This judge committing crime, tearing families apart, the county attorney, you have to let us present this man committing crimes. The FBI agent that said we'll get these recorded, they got his, they must have locked his ass up in the dungeon some goddamn where. So he'll never be able to show his face again. But he told my wife every goddamn thing I told him was true. If this judge didn't sign orders telling me he didn't conduct an emergency hearing and he ain't conducted no such hearing now, yeah, we got a jurisdiction to investigate him and the United States Attorney has jurisdiction to prosecute him for making fraud upon the court. They won't let us, so he got these attorneys there. These attorneys are not here to help us. They are our advocate. They have to, so long as the issues, whether they are supported, so long as these issues are, for example, they cannot present an issue where a prison say that the prison system will be frivolous, refuse to provide him peanut butter. That's frivolous. Of course, though, they don't have power to try no stupid mess like that unless he can show that he has to have that peanut butter for medical reasons and that and it's essential to his life or her life. Otherwise, it would be frivolous. Or because they refuse to provide him a TV, a color TV. That's frivolous. But the issues that we're providing are not frivolous. This is 20 minutes. I end this video.